evaluation of an appeal. When appeal of an administrative decision comes to ZBA, the members should keep in mind that they are not issuing a new decision. Rather, the ZBA is simply required to decide whether the previous decision made by the body whose decision is being appealed based on an ordinance standards is defensible. In doing so, the ZBA shall only review the facts as presented in the reviewing body and accordingly determine if the ordinance standards were applied correctly. ZBA members are evaluating the case on the information, and this is in bold, originally presented to the administration, not new information, because we had a question about that the last time we had an appeal. There is to be no new information given, only stuff that was presented to planning before. Anybody have any questions on that? Okay, we're gonna start out with case ZBA 21-2257. Michael Brogan requests an appeal of the Planning Commission's decision on June 8th, 2021 to deny a location variance from the 300-foot setback requirement marijuana facilities are required to maintain from residentially zoned parcels at 817 West 12th Street, Flint, Michigan. It's ZBA case 21-2257.
Mr. Chair, before we start with the applicant, I need to excuse myself from discussion and voting since these are appeals from the Planning Commission.
Right, and legal, in the past, we've had Planning Commission has the representatives been able to participate in these and give us input, because that's part of the reason that we have, because it's continuity from planning, but then abstains from voting. And only recently, the last time we had an appeal where we told her she couldn't participate at all. I've served on another municipality zoning board of appeals, and there the planning representative absolutely participated and I'm asking for a formal legal written opinion on this. I personally think, and I'm wrong a lot, that's an error, that she should be able to participate, answer any questions that we have, but abstain from voting.
Okay, I will research that and provide you
Thank
with a
you.
written legal
The
opinion.
previous city attorney, when I first came on, had done a legal opinion of that. I know sometimes it's hard to find records in the city. But I don't know if that will help you or not.
All right, I will certainly.
It was
check
Reed, I believe, if I'm right.
Okay, all right,
Okay.
thank you for that information.
All right. So with that, we're going to have our applicant present on case 21-2257.
This is Michael Brogan, appearing on behalf of the applicant. Can you hear me?
Yes, thank you.
Okay. Also with me is Robert Massey, who is son of the Barbara Massey, who is the sole owner of RBRB LLC. I guess the first question I should ask is that we have given a packet to be distributed to each board member. And whether or not that's been distributed to them, or are you calling it new evidence at this time? That would be the most important question.
We have your packet. If there is any new information that you didn't present to the planning with the original case, we cannot consider that.
Okay. Well, the error that we're, unfortunately, as your form goes, there's only one box we could check, and that was administrative error, because the others do not apply. So in that, the only administrative error that we understand is that in watching this, the video of the original Planning Commission is that.
Can you speak a little louder? I apologize.
Can you turn this on? Yeah, we'll turn this up. I think that should work. Can you hear me now?
Yeah, that's a little bit better. Thank you.
Okay.
I've got a little background noise. I'm having a hard time hearing you.
Okay. But the original packet that was given to them by former council was not distributed at the meeting. When they were talking about the letters and things like that, the commissioner said they didn't have them. Only one person had them. I think it was the chairman.
Is that the letters of support you're talking about?
Yes, yes.
Okay, sure. We would certainly look at that.
Okay, so that was one of the necessary facts. The other was what was submitted as a drawing by the planning department. Just had a circle around it without the building or anything of that nature, or the measurements showing these people, or the board members, what the measurements were. It was more of a narrative given rather than showing the actual lines and dates, like usually appears at these meetings, showing the boundary, where they measured from to where my experience is, you have to show those things.
Is this yours or was this prepared by staff?
That's staff.
All right,
That's staff.
we've got it then.
Okay, but it doesn't show where the building is. It just shows the parcel.
And that's all it has to show is the parcel.
Well, no, because the measurements to the building.
Well, it's the incorrect build.
Corey, can you give me a little background on that?
What's that, sir? One more time.
I'm asking one of our staff
Oh.
members to give a little input.
I apologize. I had to step away from the computer. What's
No
the
worries,
question?
Corey.
Because that doesn't illustrate the building.
What's the question?
The question was, we have a map showing the 300-foot buffer around their property, and then it shows properties that it overlaps in the residential properties. The applicant's saying that it should show the actual structure, that the distance should be measured to the structure, not the property.
So I'm going to let KZ respond to that, but that has
Okay.
never been how we've done that.
Thank you.
We've always done parcel line to parcel line.
So hi, commissioners. So when we do our measurements, we do from parcel line to parcel line of our measure, and it's a crow fly distance.
So the measurement for the ordinance, if it's 300 feet from a home, it's 300 feet to the property of the home, not the building, correct?
Yes.
Correct.
Correct.
Casey?
It's the property line
Right.
closest to the building.
Yeah, but the problem is this doesn't illustrate the building.
So what we have is we have residential zoned parcels, and we've been doing from lot line to lot line.
Right, lot line to lot line, not from building to building.
Correct.
Okay.
Understand, in this particular case, the state of Michigan uses right angles from everything, whether it's residential, going to the middle of the road, right angle, going to the middle, going all the way to the building. In this particular case, from the church, if you went down to the middle of the road, go down in front of this property, you have to go another 385 feet even to get to the front of the building. The same with the residential. If you use state of Michigan going at right angles, you would also do the same thing. We're well within, just the parking lot alone at 817 is over 385 feet. There's no other access to this property.
So the
Right,
other-
but it's still just, and I understand what you're saying about the church, but when I'm looking at this, there are multiple residents that the parcel is almost completely enclosed within the 300 feet, or a majority of it is.
So the other part, the other issue with this is you can't see what the building looks like on this particular sheet. So in the meeting, the commissioner got on Google Maps. They plugged the address in, and then that's where it all went wrong, because the Google address on Google Maps is showing the incorrect building. So then they're asking questions on the incorrect, the wrong building, the wrong location, but you can't verify anything on this sheet of paper. So what should have happened is they should have gone on the Flint property portal, and that shows the correct property, not on Google Maps.
Well, let me look real quick at the one for the residents and make sure it's a proper address is put in there. Let's see, your address is 817, right?
Correct.
And that's what we all use here when we're looking at something, just so you know.
And that's what they should be using as well in the
The meeting.
planning commission meetings.
Chairman Tago.
Yeah, just so you know, what we were given, and I don't know if you have a copy of it, the diagram we're given from staff clearly identifies the correct property and then has a 300 foot measurement around it.
Commissioner Telga, Commissioner Yali,
Go
I
ahead.
have a question. My understanding from everything that I've reviewed and looked at, ordinance is based on the parcel of land and not necessarily the building or the person. So whatever we vote on goes with that parcel, not the building or the person.
Right, that's my understanding too. Thank you. All right, why don't we let our applicant continue, and after they present their case, we can have discussion afterwards.
Okay. With regard to the history of the property itself, the property has been vacant for years. Actually, I would say the land bank picked it up back in 2010. RB&RB bought the property through the land bank since 2013. It was always remained vacant. There's some discussion at the planning commission level that it was being used at some time. It has always been vacant. And we have tried to sell the property, lease the property, and been totally unable to do that. The only virtue of it that has happened recently is the adoption of the marijuana ordinance that allows new use in industrial areas. That's the only interest that has been generated on this property for years. Now, she's continued to pay taxes and keep the property up to the most part, but at this point in time, that is the undue hardship. And part of that is of course, the local economy that spiraled out of control locally here, prohibiting any other use with a building such as that set way back. It's not a commercial building up on the main street, which would be nice if we had that. It would be a different category, but this is built with a railroad track in the back, a high-rise railroad track. You got fencing along the west side between the neighborhood. You have a tree line. Then you have built into other industrial businesses, and then they have fencing between that and the roads. Now, if we're just looking at the 300 feet as a measurement, as opposed to what's buffered, and that was raised in the planning commission, is that the buffer is more the landscape than it is the 300 feet. Okay, and you actually ruled on other cases at the planning commission level that this 300 feet is less than 300 feet from another marijuana use, but it's a vacant land, and it's also like a wetland. They actually called it a wetland. So the landscape was more important than the footage. Okay, measuring the buffer, they granted that variance. Okay, this way, in this particular, if you look at our landscape, we have significant buffers. You would have to trespass over 2 or 3 things, and go jump fences, get through trees, everything just to get to that property. The only way to enter that property is off 12th Street, and you're going 385 feet to get to a building. So in looking at that, if we're looking at buffering, which is part of their ruling at the planning commission level, the buffering exists. We also have neighborhood approval, as you can see from all the letters. That's all the neighbors in that area, and it's also the party store, the church. Everybody is looking for a way out of this to get their property values up. Most of these properties around here have been land bank properties, all the individual residents. So this is something that can regenerate in the area. When you look at this particular parcel, size of that building, solid block building, so there's no problem with marijuana protection or things of this nature with that building sitting way back. You look at the investment for a building that size, we're talking around $6 million for what's intended. When you look at your local ordinances, that building meets every requirement. It's in the narrative part of what we presented. So it meets everything there. Also, the generation of the jobs, you're talking minimally 60, 100 jobs for something that large. These people have the money to do that. They can come in, change that neighborhood. And this neighborhood obviously is a mixed use neighborhood. Okay, it's not a real residential neighborhood right up against it. It's been used industrially for years. So it doesn't change the nature of the area in any way. Has no real effect on that neighborhood or the church. As you can see, they've come forward and have stated that. You also, in looking at it from the standpoint of what's the master plan? Well, the master plan indicates they're looking for new uses, new industries to come in here and change. This thing can be readapted to a new use, a new industry. I've seen it in many cities throughout the state, which I work in. It's happened, it's been a blessing to them. That, you know, they're so highly regulated by the state and by the city in their codes, unlike any other industries. Not dealing with a lot of chemicals like they used to, all those things have been eliminated. They're constantly third-party watched by cameras. All these things take place inside. So in looking at 25, 30, 40 feet, are we going to turn down for Flint 60, 100 jobs and $6 million investment in that property, which allows that sector of your city to start improving? That's the ultimate question here. If you're talking about buffers, buffers are established. Like I said, vacant land, even though it's wet, it's not a buffer, but if you call it a buffer, that's a buffer. These have real buffers, and we have neighborhood approval, faith-based approval. And like I said, the only thing that we could put on here in terms of our appeal is the administrative error. No, these other things apply. You should have another document that says confusion at a certain level because of lack of information or confusing information. That's our case.
Can we show the video of the?
Pardon?
Can we show the video of the planning commission to show, to illustrate the, you know, where she's asking about when you plug it into Google Maps, it'll show you how it got off course.
Did you present, you said you did present this to planning?
No. This was the actual planning commission meeting. So you can't really present it because it was real time, but it's showing, it's illustrating that
They're confused.
the confusion. And that's the point, that's the rebuttal to it.
Well, the rules say I'm not supposed to let you introduce any new information, but since this is pertinent to the way they made a ruling, if it's something brief, we'll allow it.
Okay, so the video, it basically it's clips from the planning commission meeting. When you see photos that are still photos, those are the photos that are in the packet. That is just illustrating the incorrect assumptions on the planning commission based on that Google map photo you see of the building. So just keep that in mind, that the photos you have in your packet were not, that's just correcting them. I don't know how, Casey, are you able to?
You should be able to share your screen.
KZ, do you have something? Was that you?
Yes. The applicant requested to share their screen.
Is this sharing now?
Yes.
Okay. Let me know if you can hear this.
This is Commissioner Jordan again. So I'm pulling up my friend's Google Maps here and looking at the street view.
Yeah, I can't hear that.
There, this is Commissioner Jordan again. So I'm pulling up my friend's Google Maps here and looking at the street view. It appears that whatever parcel lies between the subject property and Caspian Street, that it is essentially just a flat vacant, almost like a parking lot sort of thing, so that there's no sort of visual screening or buffering of any sort between the subject property and the homes.
So that's when you plug in 817 West 12th Street, what she plugged in to Google Maps, that's an actual, she's talking about that area.
Right, just so you know, in our packet, it identifies your piece of property. I looked at it on property portal. It's the correct piece of property. And then what staff supplied to us showing the buffer around there is the correct piece of property.
Correct, but she's going off of incorrect information off of Google Maps, and that's what predicating her decision on, and that's what we're disputing.
I understand.
I've got one, it's a little bit longer, because there's more questions.
Commissioners know what this property was used for
Okay.
before?
That's fine. That you've seen.
Is the building set back from the road
You don't want to say anymore.
or was?
That's
You don't want to see the other.
all.
Yes, yes, it is, absolutely.
This is Commissioner Swanson. Are you going to be using the Cassidy entrance driveway to conduct your business? Should you be approved to do this business here at this location, or would you be using the 12th Street entrance?
So again, here, if you're looking on the Google Maps, you're looking at the Kathleen Street. Can you see my cursor? Are you able to see that?
Mhm.
So they're talking about using Kathleen Street. Well, you physically can't get to that. This is the entrance over here. So,
I understand that, but we're measuring from property to property line.
correct. Okay, so that's what we're trying to illustrate is when they look at it, they're looking at these property. This is the property right here that comes up on Google Maps.
Yeah, and again, I'm looking at the property portal and everything is identified correctly, just so you know. What we're looking at and what the board has looked at
We
for this
agree.
case and what presented is a proper property.
We agree.
So I understand that you're saying you think they were looking at the wrong property, but her motion was because it was within 300 feet of a residence, and that's still the case.
Correct.
Okay, gotcha.
But as we said before in other planning commission meetings, they granted variances. Okay, based on what the property landscape was. Okay, and granted that. So and if you look back at previous planning commission, they talk about land like a wetland or something like that that people wouldn't cross. They're not going to cross this either. So I guess that's part of our argument.
And I understand that, but we have no way of verifying that because we can only make our decision on the previous planning commission's meeting and decisions packet. We were given their full packet with all the information that went with it and minutes of it. I mean, just so you know, we were given all that and that's all we can base on. I can't base it on other cases that they've ruled on, unfortunately.
Okay.
Mr. Chair, can I
Go ahead,
provide,
Lori.
can I provide some clarification on the case they're talking about?
That would be great.
Okay, so that was the case where the property in question, the proposed marijuana facility abutted directly onto a residentially zoned parcel, which was why it was disqualified. So they applied for a location variance because that parcel that is residentially zoned is entirely a flood zone and cannot be developed. And therefore the location variance was, in the view of the planning commission, reasonable because no residences would ever live there.
Right. There was none currently either, correct?
Correct. It's a
Okay,
flood zone.
gotcha.
Mr. Chair,
Yeah, Gary,
Mr.
Jerry,
Chair.
let me see if they've got anything else they want to present.
thank you.
No, we do not at this time.
Okay, so the next step, what I'm gonna do is I'm gonna open up the public hearing. If there's anybody that hasn't spoken regarding, well, again, if they want, on this case, they'll hit *6, Casey, is that it? Or is it #6?
*6.
You think I'd remember that. *6. And you can speak. You have up to 3 minutes. You need to identify yourself by name and address. After that, we'll close the public hearing. The applicant will have an opportunity to respond on anything that it was said during the public hearing. Then I'll close the public hearing. We'll comment, and if we have any particular questions to the applicant, we'll do it at that time. So I'm going to open the public hearing. Do we have anybody that wants to speak regarding case 2120-2257? See anybody, KZ?
Yes, I see George Harris. Is that unmuted?
Mr. Harris
Yes,
is already
ma'am.
spoke.
Yes, ma'am, I have.
All right, anybody else? All right, we're going to close the public hearing. An applicant, you have an opportunity to respond. No one spoke, but you still have an opportunity. You want to add something else?
Hold on one second. So one of the reasons they denied it is because it was demonstrated because it had been used for other purposes. So that's what I'm saying. So I guess they voted on, I guess just trying to reiterate the fact that they looked at that storage facility or storage building. One of the motions to decline was there hasn't been undue hardship demonstrated and that the property has recently been used for other purposes, stating that it was used for storage or it's currently a storage facility. But it's not, that's what we're trying to illustrate in the showing your committee that it's not used for storage and it's two separate buildings and it doesn't abut residential property. And that's what she was saying is there's no buffer for the residential property. Well, it doesn't abut residential property. It abuts a commercial property and then there's another commercial property, there's a street and then residential, as
Right.
opposed to the storage just being literally right next to residential.
I understand what you're saying. The ordinance says it has to be 300-foot buffer. So it has to be 300 feet from property to property.
And that's
It
where we're
doesn't
at
matter what's in
there.
between, but you're correct.
Yeah.
It doesn't have to, it doesn't abut, and I agree with you on that. And I'm
Well, that's
looking at
where
it,
we're at.
and that's what we're presented by staff too, showing your property clearly doesn't have an immediate adjacent to church or to the residential.
Yeah. We have no further comment at this time.
Okay. We're gonna go ahead and open up our part of the discussion. Commissioners,
Mr. Chairman, Commissioner Key, I just have a couple of questions for our legal representative. Okay, is legal still on?
Yeah.
Okay, legal. And I hate calling you legal, but that's the best way to get to you. I just want some facts here in front of me to help me with my decision. First of all, you said in the ordinance is 300 feet parcel to parcel from a residential area as the bird or the crow flies, right?
That is something that KZ can clarify, but it is that they measure from property line to property line.
But what's also important is when you say it's the crow fly, that means a straight line from the one property line to the next property line. That doesn't mean you go out to the street, make a left-hand turn and go down to the church. That's not how the crow flies. It's a straight, that's a straight call. Now, I might be wrong, but in my 30-some years of engineering, that's how we always did it.
So if I may speak on that, this is KZ, with an engineering background as well. So as you know, air pollution does not travel like we're walking or driving. It travels radially. So that's how we measure why we go with the crow fly distance, which is a straight line.
Okay. Thank you. So the next clarification I want to have for myself is then the 300-foot buffer that the ordinance require from the property line that the marijuana license is being applied for to the residential property line is what we're concerned about.
That, and then also, yes, on this one, yes. And then the next one is, will be the one for the church space, yeah.
Right, but the church base is 500 feet, right?
Correct.
But the residential one is 300. So the only question we got in front of us is this property line that they want to apply for marijuana license within the 300 feet buffer or outside of it? Because if it's within, the ordinance is clear.
Right,
Mr.
so
Chair.
what we do have to concern ourselves is, did planning commission make any errors in the case?
Correct.
But that's why we were asking for the variance. and
Right.
For the planning.
And
commission.
can somebody go to the planning commission meetings and read me the motion on this?
I can do that.
Thank you.
Commissioner Jordan.
That way the
made a motion-
applicant will know what we're listening to also.
Commissioner Jordan made a motion to decline the request for the location variance based on the findings that the spirit of the ordinance is to maintain a residential buffer, that the conditions are not peculiar to the individual parcel, and that there hasn't been undue hardship demonstrated in that property. And it's important to keep in mind, in order to grant the variance, every standard has to be met.
Does anybody else have any other discussion or questions for the applicant?
Chair, Commissioner Yali. I have a question.
Go ahead.
I believe this is zone F, and that's the 1974 master plan. The up-to-date master plan would be GN 1, and
Commissioner, we're still operating under 1974 ordinance
Correct.
because it hasn't been adopted yet. And
Exactly.
all we're looking for here is, did planning make an error or not?
I'm getting there, Chair. I would appreciate if you didn't interrupt me. So as a G1, so basically approving this based on the ordinance or the variance that you guys are seeking, we would basically overstepping our boundaries when it comes to legislation. Because in the future master plan, which we have to look at also when we're making these decisions, doesn't have anything in there for marijuana production and so on and so forth. So I'd encourage you guys to go to city council to get that taken care of. And maybe even at this point, back out of this petition. So as just based on the future planning board. So
Right. You should also be aware, what we're really looking at here is the city's marijuana ordinance. And that's what we're interpreting from. And that's where it gives you the halo for residence, school, or park. And I know I'm forgetting one.
This is what.
Anybody else?
Hold on. Go ahead.
Can we discuss that?
Yeah, I'm sorry, I couldn't hear you.
I was just saying, can we discuss that? So on the actual, on the City of Flint website, the GN1 Green Neighborhood, I believe is what he was referencing for the master plan. I can't.
Right.
It, but so under this, the summary of uses, it has single family residential, which there is in that neighborhood and community recreational facilities, medium impact urban agriculture, aquaculture, greenhouse, hydroponics, urban green farm, garden, etc. So again, that's what that's
Right, and I understand, but legal, you can help me out on this. What specifically applies to this is the marijuana ordinance.
Yes, so there's 5 standards on which they made their decision. None of those standards are what the master plan's future land use classification is.
Right.
That's not a standard.
There's additional rules because of the marijuana ordinance. And while I'm thinking of it, staff, could you email out to all the board members? I have a hard copy, but not an electronic copy, the marijuana ordinance so that they'll have it to reference.
I can share a link in the chat if that would be helpful.
I'm sorry, Corey, I didn't get that.
I can share a link to the website if that would be helpful
Yeah, if
right
it's got
now.
it, that's fine too.
Okay.
Whenever you can. Thank you. Anybody else got any other discussion?
Question concerning the setbacks. I'm really concerned.
Janetta, I can't hear you.
Can you hear me now?
That's a lot better. Thank you.
That is better. Okay, I need to move closer to my computer. Okay, I'd like to know what neutralizers and odor mitigation systems do you plan to use for the facility? Because I'm very concerned about the possible odors that will be created from the facility.
So there's different scrubber systems, there's air filtration systems that are in place for, and what asking what type of how do you mitigate the odor? How do you
Okay, that's so controlled by state law. This is still monitored like it's a drug. So any type of wastewater, any of those things before you have to apply to the city, also the state. They have to be approved. The entire system, mechanical, electrical, all these systems have to be approved. 90% of these things run on sensors to make sure that these things don't have. I've been in a marijuana park in Lansing that's probably 45 acres, all different uses, and you can't smell it. So all those things that mechanically are increasing each year in what most of it coming from China, and you just don't have those problems. When you drive by and you smell these neighborhood grows, things of that nature, it doesn't happen at these facilities.
Commissioner Ricks, I do want to remind you that we're supposed to be basing our decision on what was presented to planning and if they made an error. But it was good education too, so I appreciate you bringing it up.
Commissioner Yelling.
Go ahead.
Commissioner Ricks, I appreciate that question. I hope the board.
Is he muted? I'm not hearing anything.
Based on the safety and the concerns of the surrounding areas, which we are obligated to do when we make these decisions.
Commissioner, I can't hear you. Am I the only one? Maybe it's just me. My volume's all the way up.
No, I can hear him, but it was low.
Yeah, I heard Commissioner Yelling. I heard him.
Okay, thank you, Commissioner Ricks. So Commissioner Telga, what I stated was that I'm hoping that in the future, the board asks these exact questions because when we make these decisions, it's based on the safety and the health of the public around us. And I don't believe these questions are being asked at the board level. So then we're not able to ask these questions. So I appreciate Commissioner Ricks asking this question because I tried before, and I'm hoping that the board, whoever's on the board at this point takes that back to the board and we focus on the safety and the health and concern of the public.
Right, but again, our focus be, did planning make an error? All right, anybody else? Jerry?
No, I'm clear. I think everybody's expressed their views and similar to what I think too, so I'm okay.
All right, anybody else before I call for a motion?
Chairman Telega, I heard you reference the Zoning Board of Appeals toolkit, and you're saying we're supposed to make our decisions based on what the Planning Commission made.
What the Planning Commission, yeah, and what was presented to them. Actually, it's more about what they could have made an error, but we're not supposed to look at any new information.
Correct, and you referenced the toolkit. Can you tell me exactly where?
Sure.
Where that was again? Sorry, just want to make sure.
Page 49.
Oh, okay. Thank you.
Anybody else? I'm going to call for a motion. I want to remind you that if you make a motion to uphold planning commission's ruling, then you need to mention what they made it based on, which was it violates the 300-foot setback. Or that they made an error in that. Do I have a motion?
Mr.
Jerry, you
Chairman,
saying
this is-
something? Because I don't hear you, buddy.
Okay, so you're calling me out, but yes, I am. I make a motion that we do not issue a variance to this applicant based on them not meeting the 300-foot setback as required in our city ordinance for marijuana facilities.
Okay, do I have support for that?
Mr. Chair.
Yes.
The motion should specify that this is an appeal, not a variance.
Okay. Jerry, can you add that to your motion?
I make a motion that we do not repeal the planning commission's decision to not issue a variance to this applicant for marijuana facilities because it does not meet the 300-foot setback requirement as mentioned in our marijuana ordinances for the city.
Corey, you okay with that?
Yep.
All right, hearing the motion, do I have support of that motion?
Commissioner Stebbins supports the motion.
All right, we got a motion and support. I'm going to ask if there's any other discussion before we go to a roll call vote. Hearing none, staff, can you do roll call vote, please?
Commissioner Stebbins,
Yes.
Commissioner Yelly,
Yes.
Commissioner Dorman,
Yes.
Commissioner Key,
Yes.
Commissioner Rex,
Yes.
Commissioner Coney,
Yes.
Commissioner Blauer,
No, she has to abstain from this.
I
Right.
abstain.
Commissioner Talia.
Matt?
Motion passes, yes. Jerry, do you have something else before we move to the next case?
No, I'm good.
Okay, I thought you said Matt. I apologize.
Well, I said Matt because you didn't answer the roll call in time. I didn't know if you had muted on it or not.
They're not supposed to mute me in these meetings.
I'm sorry.
That's the only advantage of being a chair. All right, we're gonna go to ZBA 2122. Michael Brogan requests an appeal of the planning commission's decision on June 8th, 2021, to deny a location variance from the 500-foot setback requiring marijuana facilities are required to maintain from faith-based parcels at 817 West 12th Street, Flint, Michigan. And it's the property identification is 4119-106-007. So we're gonna go through the same thing again. We're gonna open it up. The applicant will make a presentation. Then we will open up a public hearing. If there's anybody that wants to speak about it, then we'll close the public hearing. The applicant will have an opportunity to respond to anything in the public hearing. And then we will deliberate. And if you've got any questions, you can ask them at that time. So applicant on 2258.
Michael Brogan again, on behalf of RB LLC. I guess what we'd like to do is reiterate, the only thing that we can think in terms of administrative error is that what we gave to the planning commission did not get to the commissioners, such as the letters and things from the neighborhood. That's the gist of our argument. Again, like I said, on your form, you gave us no other choice except to check that box.
I understand.
The top three do not apply to us. There should be another box, and I think for future meetings and stuff that you could have, that there's some confusion or something that was generated either by misinformation on either side of the fence. But we kind of got backed into that rather than arguing. But again, like I said, I think the spirit of it, and if you look at the ordinance, actually, it talks from property line to the property line closest to the building, not property line to property line. That's your ordinance. And that,
The map that they have supplied us clearly identifies the correct property and then shows the 500-foot halo around the property, and the building does fall within, almost the entire building falls within that 500 feet. Just, that's what we were supplied with.
no, I understand. But again, it says in your 1014, or let's see, 14, a location area map of marijuana facility or surrounding area that identifies relative locations and the distances closest line to the subject facility's building. That's how it reads, to the subject marijuana facility. And we're not sure that you measured property line to property line. That's not what it calls for.
And I understand you saying that, but looking at what we're supplied here, the building also, the majority of the building also falls within that 500-foot halo.
Right. That's why we're asking for the variance. There's a reason for asking for a variance. We understand what the nature of it, but we're asking for a variance because for the city itself to lose this type of investment and jobs and everything over 25 or 30 feet, 50 feet. Okay, when we have the mixed use neighborhood right next to it and a faith-based church, and we have them, all the letters, all those people saying this will not have any negative effect on us whatsoever, grant the variance from the neighborhood side, from the faith-based side, and possibly jobs and a new renovation of this whole particular area that could happen over time. And that's what the city's striving for.
What do you estimate your total investment as?
It's around, well, not including the building, okay? The investment minimally is $6 million, okay? I've been involved with these grows all over. At this amount, and the state allows stacking at that, the minimum requirement is like 8,000 square feet for a grow and 3,000, I think, for processing or whatever. This thing is 20-some thousand feet. They're going to stack. That's the only way they're going to make money and be able to compete, especially with the money that's coming in from out of state. So locally, this has a shot. And then some of these bigger growers coming in from out of state are investing in these smaller grows and starting to build off them. So they have a footprint in this area. And I think for the city of Flint to turn this down over adhering to 300 feet rather than a landscape buffer, which is more important, is ridiculous. You're cheating your own city.
Well, the other thing is 100% of the residents signed off on it. So there wasn't a single residential person signing off. So to me, the spirit of the ordinance or the spirit of the city is the people that live in the city, not people that don't, they're supervising over the city. It's the city, it's the residents, and they've all said yes, and same as the church. But yet, you've got board members that are,
you're adhering to 300 feet. 300 feet doesn't really mean anything. Okay, it's the spirit of the community that can come back. There are natural buffers here. If you think of 300 feet being a buffer, it could be just flat land and you're 300 feet away. That doesn't mean you could enter onto the premise, you could do this or that. It's the landscape buffer that's more important, and the people on the other side of the buffer.
So the other thing is the east side of this property fits the ordinance. The west side of this property where the building is does not fit the ordinance. So you're essentially saying, it'll say no because of land or location of the building. And the same for the church. The church building to building is over 550 feet. The issue is the parking lot of the church. And I can show you a photo just so that way, if you know people that aren't familiar with it, or you just look on Google Maps or Google Earth that has a measuring, you can see so we're arguing over a parking lot. So we're going to turn down millions, all of this, what was described, over a parking lot, over dirt. So it's hard to, jobs aren't going to come back to Flint, China, Mexico, or if you get new industry, it's going to be, say it's automated or Amazon. You could have a 250,000 square foot warehouse that employs 20 people because it's not labor intensive, and this is a labor intensive industry. You can't automate. So
it's not just the improvement, it's the landscape of the property, everything. These places, when they build it out, they build it out very nicely, try to blend it in the community, or even they kick back to the community. We've talked to the Blythe people. We originally started with one woman, then we ended up with Kristen. Kristen approached us if we could do something on the 15 feet to the west side of that building, if they could put a pathway to meet the bike pathway going downtown, because there's a bridge where it goes under the railroad track right there. And we said, certainly, we'll dedicate it to you, we'll give you that property. It's almost exactly the 15 feet they need, but we haven't followed through with that until we know what we can do or what we can't do. But we're certainly interested in dedicating that property.
So it's the uniqueness of the property is that we're trying to essentially illustrate.
I'm sorry, say that again.
The uniqueness of the property or the uniqueness of the parcel is what.
Chair, Commissioner Yali.
Can you let him finish? Commissioner Yali?
No, I just kind of want to ask some questions because
Please let them finish.
All the letters that you guys had signed.
Please mute Commissioner Yali.
I've actually.
Please mute him.
Looked into.
Please mute him.
Go ahead.
You'll be able to speak as soon as they say they're done. Right away.
Well, I mean, this is the only other stuff I was going to. Okay. Yeah.
Do you have anything else in presenting?
No. Yeah.
No, we'd just like to reiterate any comments we made previously regarding the other variance request.
Okay. Commissioner Yali.
Okay, so I appreciate the letters you guys got from the neighborhood. That's a really important thing to do. I did my research on that, and most of those residents are not the property owners of that place around. So that's where my concern is if you guys reached out to the actual property owners. Actually, one of those properties that you had signed is owned by the land bank. So I think in the future, when you guys research, make sure that you are working with the property owners and not the people who are actually living there, because that, as a property owner, that's very important that they are making that decision and not the whoever's renting it or is in that area. It's a really hard decision, and we'd like to be able to vote for this. We're probably one of the organizations that can make exceptions to the rules. And it's disheartening that we can't because of legislation. We would actually, in the situation, would be making legislation if we approve this marijuana facility because of the master plan, the G1, which is you guys are 6,000. So it says right in that master plan, when you take a look at it, a marijuana facility, when you look at the G1, it does not one way or the other allow that. So that's a city council situation. So if we actually voted on that, that would put legislation, we would be making legislation at this point. So it's an unfortunate that we had to vote it down. And so that's the final thing.
Okay, thank you. If anybody else speaks, I'm going to open up the public hearing. And if there's anybody in the public that wants to speak for or against this, I'll give them an opportunity at this time. Please state your name and address. Casey, do we have anybody?
Yes. We have either.
This is Tim Stevens representing the Flint Church of Christ. As I understand it, this meeting is not to extend a variance, but just to send it back to the Planning Commission. This is an appeal. Am I understanding this correctly?
Yeah, the only appeal from our ruling would be in circuit court, Tim. It doesn't go back to planning.
Well, my thinking on this is that it wouldn't hurt to go back to the Planning Commission, just from the standpoint of, they didn't make an error in what they were considering. There is actually commercial property it's within 33 feet. There's a road there. And there's already commercial property within 50 feet of a residential property.
Right, but there's
And the
special rules that
property-
apply for marijuana. We have city has a specific marijuana ordinance.
Okay. Yeah, but still, it's a commercial area, and this building that they're talking about is just about in the middle of a commercial area, and which to me would be logical to make a variance. So I'm thinking that it wouldn't hurt to verify the appeal and send it back to the the Planning Commission for further evaluation. Just an opinion.
All right, thank you. We appreciate your input. Legal, just to make sure I have it right, I am not misspeaking. We are making ruling if planning made error or not. We are the Board of Appeals for planning, and there is no appeal from us other than to seek remedy in court, correct?
Yes. There is the possibility of a rehearing. I do have to do some research on that, however.
Okay. Can you, when you copy that, can you copy the applicant also? If that's appropriate?
If it's appropriate, I will.
Okay, I thought so. Just didn't want overstepped. All right, do we have anybody else that wants to speak from public? You see anybody else, Casey?
I see George Harris.
Michael Brogan again.
This is George Harris.
Go ahead, George.
Okay, thank you, ma'am. I'm for this. The one gentleman was saying that the people that don't have it isn't the owners of the property. My mother owns this property that I'm at, and I can talk to the other owners. Like I said, I've been around there since 1968, and I've seen everything come and go. This would bring in jobs, and I can tell you more and more and more about that neighborhood. All of us went to school together, every one of us. And you don't get neighborhoods like that. And every one of us is for this. I mean, and I think it would be good to go back to the commission to maybe have another look at it, like Tim said.
Okay.
And I'd very much appreciate it.
All right. Thank you.
Thank you, ma'am.
Yeah.
Mr. Chairman, if we could, you've asked legal counsel to look into the possibility that this could go back. With regard to the church, very important to us that possibly we could get a rehearing on that. If that was to be granted through the Planning Commission with regard to the church, we could reconvene and file a new motion under the Blythe elimination with regard to the residential area. So we're asking you to take this under.
I think that you can still do that. that's basically a new case or new circumstance to your case. You
I do
can't
un-
present the exact same case over.
No, I understand that. But the difference is the Blythe elimination is only with regard to residential. It's not with regard to the church. So
Gotcha.
right now, we're talking about the church. I would like to take this under consideration until you get legal counsel opinion.
At this time, there are no exemptions for churches. There are only exemptions for residential and for blight and for parks, but not for churches.
Well, I do understand that. That's why I'm seeing if with regard to the church issue, rather than you denying it tonight, if we could go back in front of the planning commission on that one issue. So we could keep this option open, so we could go forward on the Blythe issue.
Chair, Commissioner Young, I believe we have the right to postpone the vote. We don't have.
Ryan, we've already heard the case. We've got to vote on it.
I mean, according to the handout that we got here, we can ask this toolkit thing, which I read thoroughly and highlighted. We have the option, I believe, if city attorney can correct me if I'm wrong, that we could and we can postpone this for a future vote.
Joanne, I think that's the applicant, isn't it? And the applicant has already postponed it once.
Normally, if the applicant has postponed it once, it is within the discretion of the commissioners on whether to postpone it additionally, but normally that occurs prior to the hearing.
Right. And we're in the middle of a hearing now. So
Commissioner
Yali, it's my decision. We're going to move forward with this.
Okay, it's my understanding is we're not asking for postponement. We're asking you to take it under consideration, which you have up to 30 days. My understanding, you have up to 30 days in reviewing this prior to your decision. The board has that right.
Okay, I'm going to close public hearing. Board, do you have any questions for the applicant? Or hold on, apologize. Applicant, you're supposed to have an opportunity to respond to the public hearing.
Well, Rust.
All right, thank you. Board. Anybody? Hearing nobody, I'm going to ask for, we have a motion on 21-2258.
I guess you're gonna call me out again?
I think you just volunteered.
This is Commissioner Key. I would like to make a motion that we do not appeal the rejection of a variance for the marijuana facility as applied for from the applicant because it does not meet the 500 feet from a religious institution requirement as stated.
And it has nothing to do with it.
Marijuana ordinance.
Do we have support of that motion?
Commissioner Stebbins will support the motion.
I've got a motion to support and support. Do I have any other discussion before I ask staff for a roll call vote, please?
Chairman Telly, this is
Yeah, go ahead.
Commissioner
Commissioner
Norman.
Dorman.
So, yeah, I'm the new guy to the board, so I just want to make sure that while I am sympathetic to the applicant, that I'm understanding my role here, and based on what you showed me in this handbook, it is that I'm supposed to only review the facts as presented to the reviewing body, which is the Planning Commission. Is that correct?
Correct.
And and accordingly determine if the ordinance standards were applied correctly. And that's the decision that the planning commission made. I need to decide whether or not that decision was made correctly. And as I understand it, this property, the property line, does fall within 500 feet of a place of worship.
That's
property
correct.
line too. That is correct. And so with that said, I see that the decision made previously was that the location variance based on the findings, they declined it based on the findings that the spirit of the ordinance is to maintain a buffer, and that the conditions are not particular or peculiar to the individual parcel, and that there hasn't been undue hardship demonstrated, and that the property has recently been used for other purposes. And so, given that that was the official decision, and based on the facts presented for that planning commission, I think I understand it to be my duty on this board to decide based solely on that information.
That's correct.
That is correct. Okay.
Thanks for asking. Anybody
no
else
problem.
before we have a vote?
Commissioner Chairman, Commissioner Key, just to make sure that I reinforce to our new member here, that's exactly what I reflected in my motion. Okay.
Okay.
I may have
Anybody else?
said it a little differently, but that's exactly.
No, not at all. That's how I interpret it
Yeah,
as
he
well.
might
I
have been a little more eloquent than you.
No, I was just rereading.
Commissioner Stebbins, you have something?
No.
Okay, you were all lit around the, when I looked at it. That's why I asked. Anybody else? Hearing none, we have a motion and support, don't we? Been so long. We're gonna need to have a roll call vote.
Commissioner Stebbins,
Yes.
Commissioner Yelly,
Yes.
Commissioner Dorman,
Yes.
Commissioner Key,
Yes.
Commissioner Ricks,
Yes.
Commissioner Coney,
Yes.
Commissioner Teliga.
Yes. Motion fails. So we're going to move on to ZBA 21-2259, True Storage LLC, requests a use variance to allow operation of a mini storage facility in the D3 district at 3711 Lapeer Road. And we have an applicant on hand to present the case.
Yes, sir.
Can one of
Would you
you,
like me to proceed?
the representatives, give us
Did
an
you want me to
overview of the
proceed,
case,
sir?
please?
Yes. My name is George Reisig. Nice to meet all of you. I remember going to City of Flint council meetings back in the old days. I think I'm probably older than all of you, when Harry Cull was mayor and George Polis was mayor when I was a little kid, and Mr. Mason was on the board with his booming voice. So it's nice to be back. The applicant is seeking a variance, a use variance for the former Farmer Jack store, if you recall that. That is on Central Road in the Eastwood Commons or East Ridge Commons Shopping Center. The building is right next to what is now the Ashley Furniture Place there that used to be the Target store, right off the expressway at 69 and Center Road. The building itself that we're talking about is about 73,000 square feet. The zoning on the parcel is D3, which is Community Business District. That doesn't currently allow or accommodate this particular use. And I think the reason it doesn't accommodate it is at the time the D3 district was thought of, there wasn't this type of use. The use we're looking for is fairly new. It's indoor private storage. It's not the outdoor storage with the long rows of cement buildings with garage doors on it and the low pitch roofs. This is all indoor, completely indoor, climate controlled storage. If you think of it, much like what U-Haul is doing over on Ballinger and Miller Road, but we don't have the trucks and all the rentals and the outdoor storage as well. Use variances are permitted under the Michigan Zoning Act and also under the Flint City Ordinance. I trust, I submitted about 4 months ago for this, a 10-page summary of our arguments. And I'm actually just going to go through the highlights of it because I assume that in the 4 months since we've submitted it, the board members have had a chance to review it. If not, tell me and I'll get long-winded. If not, I'll stay short-winded, okay? The use variances can be granted under the statute and under your ordinance based on the same criterion. And that criterion is whether or not there's an undue hardship. Your ordinance goes further and cites 5 factors for the board to consider in determining whether there's an undue hardship. And I'm going to go through those now very briefly. I will not just regurgitate everything that's in my 10-page presentation. That's something you have read and can take in and understand clearly. First is the property. The first criterion is that the property cannot be used or put to a reasonable use, according to the ordinance, for the purposes permitted in that zone. Well, we know that this is zone D3 for a 73,000 square foot building, former big box, correct? Is what is typically allowed in this area. However, right now, what are we seeing in our country? We're seeing a move away from big box stores, and what the big box stores used to do, Amazon's doing online, Etsy's doing online. E-commerce is basically taking over and causing a lot of closures. Some of the statistics that I've cited in our summary are 25, according to CNBC, 25% of United States malls are projected to close within the next 3 to 5 years. 25% of malls. We see some of these being converted to other types of uses, but of course those uses which were being broken down into executive offices and break down into smaller office developments for these big box stores, that's going away too, because now we're seeing with the COVID pandemic that people are moving away from the offices and towards remote, just like we're doing tonight. 20 to 25% of the workforce will be working remote within the next couple of years. This is 4 to 5 times more than used to work remote just a couple of years ago. Office space reductions are planned to be about 30% over the next few years. Demands for restaurants and retail are going down because of COVID. Because of COVID, now you get restaurant meals delivered to your door rather than going and having the quote restaurant experience. People still enjoy that, but just not as many. In 2020, the share of e-commerce grew at 2 to 5 times faster than the rate that it was growing before the COVID-19 pandemic. This COVID-19 pandemic has done lots of things, most of it bad, but some of it just merely showing us what was bound to occur anyway and just accelerating it. E-commerce retail increased 330% in 2020 over the 2015 to 2019 period. What does that mean? It's not just a statistic. It means that brick and mortar is going to die eventually. Brick and mortar retail is going to die. 4 months ago, just some examples, close to home. Eastland Center in Harper Woods closed, 640,000 square feet closed and is going to be demolished. They used to have a Target store, just like this center, had a Sears, a Burlington Coat Factory, and Macy's. Cortland Center, across the street from this, has large spaces unoccupied, some of them up to 69,000 square feet. The former Lowe's store behind the Cortland Center over there, 140,000 square feet. It's been vacant for a few years. Between early 2020 and the end of this year, general nutrition centers that they're a staple in every mall and every shopping center. They will have closed 800 of their 1,200 stores. That is a 2/3 reduction. Pier 1 has closed over half of its 900 stores, 2 of them in Genesee County. Steinmart, one right near this. Steinmart will have closed almost all of its 280 stores in 30 states. Bed Bath & Beyond is closing approximately 1/5 of its stores. Average size 80,000 square feet. Tuesday Morning is closing almost half of its stores, actually about 1/3, 230 out of their 700 stores. Gap's closing 230 stores. J.C. Penney's closing 240 stores. Art Van closed all of their stores. One just down the street from this. Forever 21 closed 200 stores. Macy's is going to close 125 stores. Again, I don't have to beat you in the head with these statistics. You see it. You see exactly what's happening. The point here is not to attack the economy. It's just saying we have a changing economy. The subject building that we're talking about here can certainly accommodate retail uses. It's just that the changing landscape in retail means that there will be no retail uses that are going to use 73,000 square feet anymore. So it's not the economy. It's the economy put together with the type of use that this building can accommodate. Number two, second factor is the plight is due to unique circumstances, particularly to the property, not to general neighborhood conditions. There's nothing wrong with this neighborhood. As you know, the Center Road and Court Street area is extremely vibrant when it comes to commerce. What's not vibrant are the large empty boxes, like Lowe's, like the large spaces in the Cortland Center, like the two large spaces that exist here. One is now occupied by Ashley. The other one is the one we're talking about here. So it's the nature of the property itself that causes this plight. It's not the nature of the general area here. Once again, the traffic on Center Road and Court is atrocious. And the reason it's atrocious is because it's commercially viable. The commercial viability, though, cannot translate itself into a good use for a 73,000 square foot building. That's because there's no D3 type users for this area. So it's not the area that's the issue, it's this particular property located in this area. This particular property located in almost any area. Mr. Telega, you're originally from Grand Blanc. You know where the A&P store and the Kmart store were on South Saginaw. That's been vacant over a dozen years. It's finally going to get redeveloped, but they're going to tear down the big buildings and put smaller buildings in. So it's not Flint, it's everywhere that is seeing this. The third factor is that the proposed use will not alter the essential character of the area. If this use variance is approved, and once again, I'm not going to go through all my spiel that's in my 10-page report, but if this use variance is approved, there's going to be no visible alteration of the character of the area. The use will not affect the character of the area, except I think in a positive way, by filling a vacant 73,000 square foot building, generating additional commercial activity in the area, in that Court Street Center Road area, and the commercial activity generated by use is on a minimal side. This is not an anchor by any stretch of the imagination, and I will not try to sell it to you as that. But what it will do is it will not require any additional infrastructure. This type of use doesn't require large parking fields, even though there's a large parking field there. The building will look nicer once it gets branded into the True Storage brand. You're not going to have a lot of traffic going in and out in this area. This generates minimal traffic, maybe 40 to 60 cars a day, which is very small compared to what a lot of places, a lot of D3 uses would generate. Later, Mr. Dong and some of our other presenters can answer questions about the specific operations here. I'm not an operations person. I'm a lawyer. My knowledge is very limited of these operations. I'm familiar with them, but they know a lot more than I do, and they can answer those operational questions. Let's take a look at the master plan for a second. You have a place-based land use map. It designates this area as PC, or production center. Production center on page 7 of the master plan says this: production centers are designated where the city's major industrial centers and economic centers exist, such as GM's Flint Truck Assembly and portions of the Buick City site. These intense industrial uses are capable of generating considerable noise, traffic, and other nuisances, and should be separated from residential and commercial areas. It indicates, it also says the types of uses. It has a table. The table has 2 codes in it, an S code and a P code. The P code is permitted, the S code is a special use. The storage uses are listed as P code uses in the PC district, and this is designated as a PC district. So this, under your master plan, fits right in what the use table of your master plan calls for. Finally, right next door, the Ashley Center, the old Target store. Once again, I don't cite this as precedent, but I cite this as realization by the city that this is a good use for this area. The Ashley Furniture Retail and Warehouse and Distribution Center got a approval of use variance by the city because the city determined that warehousing, at least in the Ashley sense of warehousing and distribution and storage uses, were appropriate on this site.
Yeah, Attorney Rizek, that actually did come in front of this board. We approved it, and I was going to let our new member know that that in that same building there, that same facility, Ashley asked for a variance to build a warehouse on the back, and it was approved. And he's also, just so you know, Derek, he's also correct. The ordinances we're dealing with were written in the 1970s for the city of Flint. Flint's revised new one, the council hasn't seen fit to pass it in the past 3 years. So there is no ordinance that allows for storage within the city zoning, is my understanding.
And certainly nothing that even contemplates in its wildest dreams indoor storage from 1970, indoor climate controlled mini storage. The next factor of your 5 factors is this is not a self-created hardship. A lot of people misunderstand the concept of self-created. Self-created means that somebody did something to the property. They changed the property. For example, made it smaller, made it narrower, knocked down a portion of a building, or did something that made the hardship possible or caused the hardship. Actual asking for a variance itself is not a self-created hardship. That is not what the term self-created is. In this case, the applicant has not created the situation that necessitates the variance request. When this building was first constructed decades ago, it didn't present a plight to anybody. It was a perfect use for this area. It was a nice commercial center for a long time, but that was and it was developed according to the proper zoning and the market at that particular time. But the plight that we have is not the result of anything that a property owner has done or any person that's been entitled since the property was developed. The plight is caused by this total paradigm shift in how things are purchased, not by driving, a couple miles, parking your car in a parking lot, walking a couple hundred feet to a storefront, going inside and waiting in a takeout line in a large brick and mortar store, sort of a general merchandise store. Now, you put your finger on a mouse, you have your favorites. Amazon doesn't even let you search anymore. They say, want to buy this again, and you click. You don't even have to put your credit card information, they save it for you. So all those places, you open up an account online, 2 or 3 clicks, and your house is stocked for a week. The 5th factor is issuance of the variance would ensure the spirit of the ordinance is observed, public safety secured, and substantial justice done. The substantial justice, I think that Chair Telega just told us, substantial justice is, what have we done in this area? Is it just to do this for people other than, for example, Ashley? And I think he was leading us there in mentioning that. This is high quality, indoor climate controlled personal storage. As I said, this was not anticipated by the zoning ordinance when it was drafted back in 1968. The most recent amendments to the ordinance, the most recent amendments were in 2008. That's 13 years ago. There were only a handful of indoor storage buildings in Michigan at that time. And once again, at that time, if you would have said mini storage to people, it carried the same stigma that it had today. And that is these long, low rows of cement block buildings with the fence around it that's half down with a razor wire on the top as if it were some sort of prison, and with a small building up front or an electronically operated gate. This is different, okay? What you see is a couple entrances, 2, maybe 3 entrances to a mini storage building, indoor climate controlled mini storage. You see a facade on the outside that is attractive. You don't see a fence with razor wire or barbed wire on top. You don't have a gate that's going up and down. You have limited hours. This sort of indoor storage is limited. It doesn't go all night. I can't drive in the middle of the night and go up and pick something from my mini storage place. Okay, and so you don't have the security issues and security breaches that you have in typical outdoor mini storage. the current building being vacant certainly doesn't help public safety. What we're going to see is this. If this is used for mini storage or any use, for that example, any decent use, you're going to see an increase in value of this redeveloped property. And then, of course, that's going to, every development spawns surrounding development. If you have a bunch of empty buildings, it takes a pioneer to go in and make that first step. And then that pioneer, he or she, hopes that they're helping develop in the area. When you fill up a 73,000 square foot building, you're doing a lot of uptake on open property in the area, so that the value of all other rental property goes up in the area, because you've eliminated 70,000 square feet from the denominator of that fraction, from your base rate. You're going to see an increase in local business demand. These service businesses in the area. So any business, whether it's a local accountant who wants to store records, if there's a local lawyer who wants to store his old files, somebody, a lot of times you see the guys who have the potato chip routes or the candy routes, they use mini storage to store their inventory until they go and turn it in a store, in the grocery store. Mini storage is really big for those people who have routes where they sell merchandise that they store or that they take on consignment. It also reduces blight in the area. You have either an empty parking lot in front of here with weeds growing up through it, and a store that's shuttered, dark space as they call it, or you have a place that's open with cars going in and out, okay? Not a lot of vehicles, it's not gonna put a burden on traffic, but vehicles going in and out, there's activity. It's like any place else where there's activity, you have your security breaches go down. And there's gonna be job creation. I don't know how many jobs this is gonna create. The applicant himself can speak to that, but to the extent it creates any jobs, that's great. And any spin-off commercial activity, when you fill up 70,000 square feet of commercial space that's been vacant for years, is bound to help the area. And once again, then the public safety issue. Public safety, as I mentioned, is one of the key features of indoor storage. If we were asking for outdoor storage facility, we'd be looking at, once again, that area where people jump fences, where they crash through fences, where they're coming in all hours of the day or night. The only control is the card they have or how hard they're willing to crash the gate. This, as I said, is very limited entry, limited access, everything within walls. And then once you get inside there, you have a second level of security, and that is each of those units inside is secured as well. So I think that we've addressed in our 10-page report, in the documents that Mr. Don has provided, and hopefully today in my presentation, the 5 criteria for a use variance. I stand ready to answer your questions, as does the rest of our team here. Thank you.
Is anybody else going to present on behalf of the applicant, or just to be for questions?
I think probably for questions, sir.
Okay, all right. So what I'm going to do now is open up the public hearing to see if we have anybody here that wants to make a comment on that. If you do, please state your name and address. KZ, do we have anybody on the line?
We do not.
All right, well, I'm going to close public hearing then. And then applicant's response. There's no one comments, so I don't think you have any response. If it's something else, Attorney Rizek, you want to mention that you maybe just thought you'd forgotten, you're welcome to.
No, sir,
okay.
I said
All right.
enough. I've taken it.
All right.
You guys want to get home, so.
So before we move into it, just for our new Commissioner Dorman, he's correct. Our ordinances were written in the 1970s before, and this type of business didn't exist. So there's no way for them to apply to meet or build anywhere. Secondly, just for your background, we recently approved a very similar project in the Southlet Plaza. And again, I've written down here, I will ask staff to implore the council to pass the new zoning ordinances, because there'll be cases that we hear that we won't even hear because if they're passed. So does anybody have any questions for the applicant or the representatives? I'm sorry, what did you tell me the hours of operation is going to be? Is it 24-hour access?
No, I don't think it's 24-hour access. Mr. Don, do you know?
I know the answer to that. This is Chris Lewis. I'm one of the partners in True Storage. Typically, the store is open from 9 a.m. to 6 p.m. with allowed access up until 8 p.m. So there'll be a representative on site from 9 to 6, and then from 6 to 8, people will have punch code access into the facility.
Okay.
I might add, Mr. Lewis, you can confirm this for me. There's a small area inside where packaging equipment like tape and boxes are sold as well.
Yes, that's correct. Yeah.
Okay. Anybody else have any other questions?
Mr. Chair, I do have a question to the applicant.
Go ahead.
Just more for clarification for record, this is not a request for a change in zoning of any sort. This is just a use variance for this particular facility, correct?
That is exactly correct.
Anybody else?
Commissioner Stebbins, I did want to ask the applicant, how many jobs would this create?
Mr. Lewis?
Yes. Thank you for the question. And during one of the things that we do during the process is we use local construction crews to do the work. So there's jobs created on the front end as we come in and do the construction. So it's re-roofing, exterior work, electricians, mechanical, plumbing. So all those are sourced locally. So it'll help that base in the beginning. As the property is open, we employ probably about 6 people in the local area. And that ranges from people that would be fixing items in the facility, whether it's the mechanical equipment, cleaning the facility, as well as people operating the facility on all levels, the management level, as well as day-to-day use.
Great, thank you.
You're welcome. Thank you.
Anybody else? I personally think this is probably a good use. As they've stated, the big box stores are going away and not likely to be filled with anything again. We have already approved a warehouse in this same property. And I don't see any conflict here at all. So if no one else has got any other question or comment, I'm going to ask for a motion.
This is Commissioner Ricks. Can you hear me?
And Commissioner Ricks, I can't hear you.
Can you hear me now? No?
Can you make it a little louder?
Can you hear me now?
I can hear you now.
It's in, this is in my ward, and I was extremely excited to see that you all were on your way, and I am going to vote yes for you to occupy this space. Thank you.
Thank you.
Thank you.
Anybody else?
This is Commissioner Key. I just got a comment. I see Commissioner Yellow's true self is trying to get on the screen here.
Yes. He's a good guy. He's been a good addition. All right. Do we have a motion to approve or deny?
Okay, I guess this is Commissioner Key. Is this where I come in again?
This, if you choose to.
All right.
You're not under any coercion.
All right. Well, for ZBA number 21-2259, I make a motion that we approve of a use variance for this request so that they can incorporate the storage facility in the old building as applied for, per meeting all the standards that we judge all applicants against.
A second.
All right, we've got a motion of support. Do we have any other discussion?
Commissioner Ricks, can you hear me? Commissioner Ricks, I second that.
No, I can't hear you. I'm just messing with you. Go ahead. Could you yell it, please? And spell it out too?
Okay. Commissioner Ricks, I second that.
We got a second and a second. Anybody else? Got any other discussion before we call for the motion? All right, I'm gonna ask for a roll call vote from the staff.
Commissioner Stebbins,
Yes.
Commissioner Yelly,
Yes.
Commissioner Dorman,
Yes.
Commissioner Key,
Yes.
Commissioner Ricks,
Yes.
Commissioner Coney,
Yes.
Commissioner Blower,
Yes.
Commissioner Telga.
Yes. The motion passes. Congratulations. Just
Thank
know
you.
that Commissioner Rixby going to be looking over your
you.
shoulders.
We look forward to it. Thank
All
you so
right,
much.
thank you.
Appreciate
Good
all
luck
the
with your
time.
endeavor.
Thank you.
Thank you.
Okay. Next, we're going to move to the city attorney report. Do you have anything to report?
I'm sorry, Commissioner, I missed what you asked for.
Do you have anything to report?
No, sir. I will be working on the legal opinion that you requested, though.
Thank you. I was going to remind you of it. You beat me to it. Okay, we're going to go to old business. And I had the opinion on Carol Ann. Then Michigan Association of Planners Training and Training Material. We asked that the new commissioners receive it, or anybody that might have lost theirs. Commissioner Yelly, you got yours correct?
That is correct.
And correct, Commissioner Dorman, you got you're reading from it, so you must have.
Yes, sir. Yes, sir, Chairman, I did receive it. This thing? Drop connection for some reason.
For specifically looking something directed towards marijuana, because in the recent months, that's made up the bulk of our case. Staff?
Commissioner Telliger, you cut off and froze. We only heard the back end of that statement. Could you start again from educational updates?
Yeah, well, we specifically asked for an educational update specifically and the marijuana ordinance especially, because a majority of our cases now are pertaining to that.
Yep, so we put that on the agenda tonight, just educational updates. We don't have the presentation on the marijuana ordinance for tonight, but at a future meeting, we'll have that. And if there are any other educational updates or things commissioners want to bring to the table to have staff present on, you can let us know.
I'd really rather do that as something separate if we can, because some of our meetings can go long like this one.
So would you like it in like a special meeting form
I would, but I'd certainly seek input from the board if they all feel differently. We certainly go with the board's will.
I'll also want to throw out that if there are no cases in December, or if there are any month with no cases, we could also do it.
Right, that's kind of what I was thinking too. Do we have anything in the pipeline right now for December?
I will have to check that and get back with you probably tomorrow.
Okay, Jonathan. Appreciate it. Okay, is there any other old business I'm missing? I don't think so. Under new business, I'm gonna ask the staff, all the staff to implore our new city council to pass the zoning ordinance, which was written about 3 years ago, about the same time as the master plan, which has been approved because we're operating under a zoning ordinance that was written when Richard Nixon was the president. And there are several members of this board that weren't even born yet. And I guess I'll ask the staff members, besides the staff members, council, if you have a relationship with your council person or anybody else, I'd ask you to reach out to them. Because they've had it, and it's my understanding, staff maybe correct me, that they were gonna feed it to them in portions. They did approve a small portion of it, is that correct?
Joanne, did you want to answer this one?
Yeah, well, there were some issues with the first 6 articles that was approved before council, and so we've had to backtrack. Right now, there is a plan by the Planning and Zoning Development Department to bring the full 18 articles before council with the intention to have it all approved at one time.
Okay. Joanne, for background reference for you, this board has been asking for over 2 years for that to happen. And we were told, first we were told it was the council, then council told us it was staff, then it went back and forth again. We've heard it all. We're asking you, we've heard this before, and I apologize. We need this approved. There are cases we're hearing, and potentially cases that may be turned down that we wouldn't even hear under the new ordinance.
Yes.
I'm sure you can hear the frustration in my voice, and I apologize.
No problem. It's all new to me. So, but we do have a plan, and with there being new council members, there will have to be the re-education that happens. And so we are prepared for that as well.
So what's the timeline?
I believe the first couple weeks in December.
Can you continue to report back under old business the status of it each meeting we have? Give us updates.
Absolutely.
That would be wonderful, and I appreciate it.
No problem.
And then staff, we do not have an updated roster with Commissioner Dorman and Commissioner Yelly's contact information. Can we get an updated roster sent out to the board with their information?
Yes, we can definitely do that.
Thank you. Thank you. Anybody else got anything under new business?